Article 90B C. Article 39 Clause B C directs state to shape a policy towards securing equitable distribution of the material resources of the community and prevent a concentration of wealth, means of productions. The provision aims to establish equality in the society and thereof law giving effect to these principles cannot be taken to violation of the fundamental rights. Article 1419 which guarantee rights to equality and right to freedom दिया है. आर्टिकल 39B बोलते हैं पॉलिसी टुवर्ड्स सिक्योरिंग इक्विटेबल डिस्ट्रीब्यूशन ऑफ material sources of community sources and to prevent a concentration of wealth and means of productions. सब इक्वली डिस्ट्रीब्यूशन होना चाहिए. द प्रोविजन एम्स टू एस्टैब्लिश इक्वालिटी इन द सोसाइटी एंड देयरऑफ लॉ गिविंग इफेक्ट टू दीज प्रिंसिपल्स कैनॉट बी टेकन टू बी वायलेशन ऑफ फंडामेंटल राइट्स को वायलेशन नहीं होना चाहिए. आर्टिकल 13B गिव डॉक्ट्रिन ऑफ थ्योरी ऑफ हार्मोनाइजेशंस. It has further stated that both fundamental rights and duty principles completely complementary and together constitute an integrated scheme, but whether they cannot give in the supplementary positions. Fundamental rights prevails over the judiciary principle के ऊपर. Fundamental rights. संविधान में एवरीथिंग रिटन इन द संविधान कॉन्स्टिट्यूशन. कॉन्स्टिट्यूशन को कौन जानता है? कोई नहीं जानता है. टीचर्स नहीं पढ़ाते हैं, टीचर को नहीं आता है. बिल नीडेड टू पास इन ईच हाउस बाय द स्पेशल मेजोरिटी में कॉन्स्टिट्यूशन अमेंडमेंट बिल. मेजोरिटी इन टोटल मेंबरशिप ऑफ द हाउस and majority of the 2/3 of the members of the house present. Majority total presented 2/3 and voting. The bill must be duly passed by both houses and separately because joint sitting is not available. Any such bill which tends to amend any federal provision को amend करते हैं, joint sitting not available. Both bill must be duly passed by the both house के द्वारा. Federal provision must be ratified by the legislative on behalf of the states by a simple majority. 2/3 majority of the parliament by simple majority and ratified by the legislative of half on behalf of the state. After being duly passed, it must be returned to the president must be presented to the president for assent के लिए, to which he must give assent देना पड़ेगा, because the such a bill can never be withheld नहीं होगा, return for the consideration के लिए नहीं जाएगा. The bill becomes an act after being assent by the president, act हो जाएगा. However, the procedure has been criticized on several grounds में criticize हो रहा है. Most significant of which is the absence of separate body for amending the constitution. Most significant of which the absence of a separate body amending the constitution. Separate body constitution को amend करेगा. The amending powers have been vested in the parliamentary, which can amend either by special majority by the simple majority amending. Only in the case of amending the federal features of the constitution, consent the state required the federal structure के लिए. Most significant of which is the absence of separate body for amending के लिए नहीं. Western parliament में. This has exposed the power of amendment to the possibilities of being misused by the central government. This has exposed power of amendment. Some instance would apply. केंद्र सरकार कुछ भी कर सकता है. इसके लिए फेडरल गवर्नमेंट बहुत सारे राज्यों का सरकार चाहिए सरकार बनाने के लिए. नॉट फ्लेक्सिबल गवर्नमेंट चाहिए. सेंट्रल गवर्नमेंट सम इंस्टेंस वुड अप्लाई clarify the situation. 38 amendment barred the judicial review to the presidents. Judicial review of presidential orders. 38 amendment हुआ था. First order suspending the enforcement of. भारत के संविधान को कितना बार कुचला गया है, फिर भी जिंदा है. 38 review of presidential order suspending the enforcement of fundamental rights suspend हुआ था. Followed by 39th amendment which ousted the jurisdiction of a court with retrospective effect, which ousted the jurisdiction of the court respective effect in respect of any petition challenging the prime minister election to the Lok Sabha. प्राइम मिनिस्टर इलेक्शन को चैलेंज किया जाएगा, उपवास हो जाएगा. 38 अमेंडमेंट 39 अमेंडमेंट पुट द रिप्रेजेंटेशन ऑफ द पीपल एक्ट. People Act 1951 together with the motivated 1975 amendment in the 9th schedule of the Constitution, so that it became protected against the challenge on the ground violation of the fundamental rights. There was the historic 42 amendment, which sought to institutionalize national emergency. 1975 Co. These are sufficient to indicate that amendment of the Constitution have often been handmade of center का हाथ में to satisfy petty interest of enhancing the powers of the party का power को enhance करने के लिए power at the point of time. बहुत सारे के टाइम भारत में लोकतंत्र को कुचला गया है जनता तमाशा देख रही है कुछ नहीं कर रही है. Procedure has been criticized several grounds, most significant of which the absence of separate body for amending the constitutions. Only in this case, amending the federal features of the constitution, concept of state is required. The federal government, some instance, would apply the clarify the situations. Third amendment. Which article the constitution can be union government plays its roles in setting interstate water dispute. Under Article 262, 263 interstate Constitution of India, Union Government legislated for setting of interstate water dispute. Parliament made law by providing for the adjudication बनाएगा any dispute of complaint with respect to use, distribution, no control of waters or any interstate river or a river valley and excludes any jurisdiction of the courts. It provides for settlement of this class of dispute by extrajudicial tribunal. Actually, judicial के बाहर. Law providing adjudication of any dispute or complaint with respect to use, distribution of control of waters, distribution and control of water of any interest river or river valley and exclude rates.